But let's go ahead with the first case, Mays versus the state of Michigan.
May it please the court, my name is Nathan Gambill. I represent the state of Michigan, the Department of Environmental Quality, the Department of Health and Human Services, and also former Governor Rick Snyder. With me at council table is Richard Cole and Eric Restuccia, also from the Attorney General's office. Also at council table is William Kim, Assistant City Attorney for the City of Flint. He is representing the City of Flint's former emergency managers. I will use 20 minutes and Mr. Kim will use 10 minutes. And I'll reserve 5 of my 20 minutes for rebuttal.
Okay.
The 3 primary issues in this case are whether the plaintiffs can pursue a constitutional tort against state agencies, whether they can pursue inverse condemnation claims against state agencies, and if so, whether the plaintiffs have satisfied the Court of Claims notice provision. Note that the court need not reach the notice provision issue unless it rules that the constitutional claims can proceed. The plaintiffs in this case are not every Flint resident. They are 6 individuals. And these 6 individuals have filed suit in a variety of different courts under a variety of different theories, pursuing well-established judicial remedies in those other courts for the very injuries that they allege in this suit. But this suit is different from all of those other suits because in this suit, the judicial remedy they seek does not exist. The plaintiffs are asking this court to create it. The plaintiffs seek to bypass the Governmental Tort Liability Act entirely and to pursue damages directly against state agencies under the Michigan Constitution. To pursue that type of judicial remedy, the plaintiffs must satisfy heavy legal burdens, and they have not satisfied them here. First, the plaintiffs, throughout their briefing and throughout their pleadings, have made a very common mistake, which is that they have attributed anything a state employee has said or done or written automatically to the state itself. But Smith claims cannot be based on respondeat superior liability. That's not how they work. Under Smith, this court has incorporated the Monell Doctrine from the federal courts, and that Monell Doctrine is meant to put a check on that sort of assumption, to put plaintiffs in a position where they must show that the violation, the constitutional violation they allege was deliberately caused not by some state employee, but by the institution itself. So in this case, the claim that the violation they allege is exposure to toxic water. So to satisfy their Monell burden, the plaintiffs must show not that state employees did something to expose them to toxic water, but that the institutions themselves deliberately caused their exposure to toxic water. That's what the Monell burden is. The plaintiffs do not satisfy it. There has never been any kind of directive from any institution or any top policymaker in any of these state defendants that directed that the plaintiffs be exposed to toxic water. That has not happened. It does in Monell cases. That's generally what the fact pattern is in a Monell case. For example, the Monell case itself, in black and white, the city of New York's official government policy required managers to discriminate against pregnant women. So there was no question there whether it was an official act of the institution itself that caused the alleged constitutional violation. Here, there's nothing of that nature at all. No institution has ever mandated that its low-level staffers go out and make sure that Flint residents are exposed to toxic water. It hasn't happened. The plaintiff's failure—
A mandate is not the only way in which you can establish the Monell claim, right?
Yes,
you can have a final policy decision or decision by a final policymaker, which becomes the policy, custom policy of the state regardless. So can you address that of in a choice of options when a final policymaker makes a choice, like the one they did here, why is that not attributed to the state when, under many cases under Monell and in a 1983 context, that would be sufficient to establish Monell liability?
So I believe the case that Your Honor is referring to is the Pimbar case, which both parties discuss in our briefs. And Pimbar holds exactly what you said, which is that the official policy doesn't necessarily have to be written like the policy in the Monell case was. It can be a decision by a top policymaker. But the point is that even if that's true, even if a top policymaker makes a decision, this court just 2 years ago in Johnson v. Vanderkoy recognized the distinction between satisfying that type of issue, whether the policy is written or not, and then satisfying the fault and causation components of Monell. So the Brown case discusses this in great detail. So there is no top policymaker that authorized or mandated that low-level staffers go out and expose the plaintiffs to toxic water. There's never anything of that nature. So even if under Pinbauer someone says, okay, a top policymaker made a decision, well, they still, to satisfy their Monell burden, have to say, okay, a top policymaker made a decision, but that decision deliberately caused the specific constitutional violation at issue.
Was the moving force behind the constitutional violation.
That's one
right?
of the ways that the
So
courts have used it.
the intent to injure or that type of, it's not quite the standard for, I mean, you can be a moving force, a policy decision can be the moving force, and I think plaintiff's theory is that you chose between knowing the possibility and or the likelihood that switching to the Flint River would subject individuals to harm, and the policymakers, the state policymakers, made that decision regardless, and but for that, they were therefore the moving force behind that, regardless of whether they intended to injure somebody. Their decision was a moving force behind the injuries that were eventually suffered.
The Brown case speaks to this issue, and it's the case that we discuss in our briefing. And if you look at pages 410 to 411 of the Brown case, and explains that a but-for cause is not enough to satisfy a Monell burden, because it cautions, and the Supreme Court has cautioned that, the U.S. Supreme Court has cautioned this regularly, any decision by a state employee can eventually be traced back to some policy if you go back far enough, and we discussed that on page 24 of our brief, but that isn't enough. And another premise of your question, Justice Cavanagh, is that the state policymakers made the decision to switch to the Flint River, and in page 4 of the plaintiff's brief, they actually acknowledge that that is not accurate. They recognize that the decision that the Andy Dillon, the state treasurer, that the governor was involved in, was allowing Flint to join the Carragandi Water Authority. The decision to switch to the Flint River happened later. It was after DWSD canceled their contract, and suddenly Flint found itself in a position where it had to find an interim source of water, and the city is the one that made that decision. It sought approval from the state, just as any other municipality would need approval from the state to switch water sources. But the policymakers in that circumstance were city policymakers. But in any event, even if we assume, Your Honor, that the policymakers of the state did choose to go to the Flint River, that still would not satisfy Monell, because the July 2011 report that the city of Flint's engineering firm prepared, it evaluated whether the Flint River could be used as a drinking water source, and it found that it could. It said the Flint River can be treated to meet all regulatory requirements. And when the city decided, after DWSD canceled its contract, well, let's do that, let's go to the Flint River, they hired that same engineering firm, Land, to come in and evaluate whether that was even possible. They paid them $171,000 to take a look at it and see if the water treatment plant could be fixed enough to put the Flint River, to use the Flint River on an interim basis. They looked at it in November 2013. They came back and said, yes, it can. We can do this. We can meet this tight deadline, hit your April 2014 deadline, and treat the Flint River satisfactorily. And so that's just one reason why the plaintiff's constitutional tort claims can't proceed. The other reason is that even if they do satisfy their Monell burden, unilaterally creating a damage remedy in the circumstances of this case would violate the separation of powers doctrine. And it's one thing if the legislature had ignored the Flint water crisis if it had not done anything. But it has squarely addressed it repeatedly and appropriated hundreds of millions of dollars to be used by the city and to the benefit of Flint residents for nutrition, economic stimulus, all kinds of different programs, but never in the many acts that this legislature has passed has it authorized a damage claim. So for the court to unilaterally create that damage claim, even though the legislature has already squarely addressed the Flint water crisis, and especially when the plaintiffs have so many other judicial remedies already available to them, they are suing a variety of different institutions, including the companies that advised Flint. They're suing the city of Flint, state employees, city employees, in a variety of different courts. These are well-established judicial remedies.
In which of those cases or lawsuits are they able to get the same remedies they have asked for in this case?
You mean damages against state
Damages
agencies?
against the state agencies.
In none of them. But that's always true. That's been true when Smith was decided. It's always been true since then. You generally cannot sue a state for damages in federal court or in state court for most of the time.
Except when you can, right? In the rare conscious shocking cases.
Well, actually, conscious shocking is not the qualifier for that. It's the Monell and separation of powers issues that I've been discussing. And so, yes,
That's fine.
Certainly, this court in 1987 authorized a hypothetical possibility that, yes, you could potentially sue state agencies for damages, and that was based on the federal Bivens line of cases, and that jurisprudence has transformed completely since
Counsel,
1987.
like Chief Justice McCormick, I'm a little confused about the argument of alternative remedies. If there were no alternative remedies, would it be your position then that the instant statute, the one now in controversy, should be interpreted differently?
Your Honor, which statute do you refer to?
I'm talking about the statute that's the predicate for this entire case.
The Smith decision, Your Honor?
I'm saying, what is the relevance of the fact that there are other statutes that do or do not afford remedies? The issue in this case is whether this statute affords remedies.
The relevance is that Justice Harlan, actually, in the Bivens decision, in his analysis, which is really caught on in different Bivens decisions, his analysis is that it really matters. If the court is going to step in and unilaterally do something that the Congress or the legislature has not done, it matters to the court whether they have other remedies available to them. And so the phrase that he made famous is the people in Bivens, they face damages or nothing. If they couldn't pursue those federal agents for damages, they had no remedy at all. And
So you are saying that this statute is susceptible to distinctive interpretations based upon the serendipitousness of what remedies are afforded by other statutes?
Yes, and so the alternative remedies analysis certainly does play into this court's decision of whether or not to unilaterally create a new remedy. So the urgency that was present in Bivens is not present here. In fact, the U.S. Supreme Court has never extended Bivens since the time Smith was decided. 10 times in a row, it has refused to extend Bivens. And, for example, in 1987, when this case was decided, in 1987, when the Smith case was decided, there was an open question whether you could pursue a Bivens claim directly against a federal agency. It was an open question. And so the Smith case understandably kept that as an open question here under state law too. 7 years later, in 1994, the U.S. Supreme Court closed the door on that question, said absolutely not. We will not infer a Bivens claim against an agency itself because that would be much too intrusive into federal fiscal policy. And that would violate the separation of powers doctrine. So that's just one of many examples of the way that the federal Bivens jurisprudence has really transformed over the years. And the main focus in Bivens cases is the separation of powers doctrine. And so I mean, all crises, including the Flint water crises, will test the strength of our institutions. The separation of powers doctrine is a core pillar of our state institutions. It's been a core pillar of the American system of government for as long as it's existed. And so it really does matter. And providing the relief in these circumstances that the plaintiffs seek would violate that doctrine. So I'll reserve the rest of my time for.
Well done.
Good morning, Your Honors, and may it please the Court. My name is William Kim, and I'm appearing here on behalf of Darnell Earley and Gerald Ambrose, who are named only in their official capacities as former emergency managers for the city of Flint. I will be reserving 3 minutes for rebuttal and understand that I need to track that myself. There are three main arguments that I wanted to raise that are specifically applicable to the former emergency managers in their official capacities. The first, I think, addresses kind of the question I think that Justice Markman was asking, in that the claims against the former emergency managers in particular could not have and did not accrue within 6 months of the plaintiffs filing this action that's before you today, because simply because the last emergency manager, which was Gerald Ambrose, resigned in April of 2015, which is almost 10 months or 9 months prior to the filing of this suit. The second issue that is particularly applicable to the former emergency managers is that a damages remedy here is particularly inappropriate against their official capacities because those official capacities are actually parties in all of the other actions that were referred to by Brother Counsel. And finally, Your Honors, the third point would be that the inverse condemnation claims against the former emergency managers in their official capacities can't be sustained because the persons who were within their jurisdiction are simply not similarly situated to persons who are outside of their jurisdiction. And so an inverse condemnation claim there should be barred for failure to meet the essential elements of that claim. In regards to that first issue, which I would like to address first, I would also mirror what Brother Counsel just said. And if the court finds for the former emergency managers on the notice issues, there's no need to address the other two specific claims because a failure to provide timely notice would bar their claims entirely. The relevant facts here, as alleged by the plaintiffs or as subject to judicial notice, would be that former emergency manager Earley served from October 2013 through January of 2015. Former emergency manager Ambrose served from January 2015 through April of 2015. And during that time, the plaintiffs alleged numerous instances as early as the spring of 2014 that there were issues with the water that was being distributed by the city of Flint. In fact, one of the named plaintiffs herself brought suit in both the federal court and in the local courts to attempt to get the city to change its policies in that area. There's simply no reason that they could not have filed their claims against the former emergency managers within 6 months of the time that those emergency managers were in office. And their failure to do so under the controlling precedent in this area should bar their claims because that 6-month notice requirement accrues upon the occurrence of the wrong and not the manifestation of the damages themselves.
What do you do with our decision in Frank, that says that the date of the wrong is not when the defendant breached his duty, but when that breach of the duty harmed the plaintiff. So the fact that your clients may not have been emergency managers at the time may be relevant to whether or not when they could have breached their duty, but that doesn't necessarily mean that their breach didn't harm the plaintiffs after they were out of office.
That is correct. However, as I said here, as I said earlier, one, there were numerous signs that there was some sort of harm that they were being subject to as a result of the switch to the Flint River. The allegations in the amended complaint that's at issue establish that those were occurring more or less as early as April of 2014. So there isn't a question here as to when the damage. There may be a question as to exactly when the damages occurred. However, those damages were definitely evident prior to either of the former emergency managers leaving office.
That sets up an interesting contrast, doesn't it? Basically, you're basically saying that people, it's when this action took place, which is when the Flint River became the source of the water, but your folks were basically telling people that this was safe. So I guess it's kind of a little bit of a contrast, isn't it? I'm just trying to understand. At a certain point, when you come before the court, you kind of have to make sense. So I guess my question here is, you basically have a situation where you were telling people that it was safe and there was no problem, and now you're saying that because people listened to you, they should be held accountable for the fact that they didn't act because they were listening to you.
Well, first I would say that the emergency managers clearly believed what they said. The information that they were getting from various sources told them that what they were saying was correct. Obviously, in retrospect,
what should they have done differently? What should the plaintiffs in this case have done differently?
well, for one thing, I think that they should have consulted with their own counsel and brought action, which is, in this case, exactly what one of the named plaintiffs did by filing suit in the case that was attached to our appendix in this area. It's not a question that they did not know that there were problems. It's not a question that they did not they did not have an opportunity to bring action. Frankly, there is no allegation whatsoever in this case that the plaintiffs believed anything that the former emergency manager or anybody from else
So under
in
your
state government was
argument,
telling
then
them.
people, if there's like then people need to just go to court. Then they shouldn't listen to government or listen to studies. Under your argument, people need to just go immediately to court.
I think there's a certain level at which people, while they need to be able to bring their claims to court regardless of what the government is saying. I mean, the government has occasionally said things that turn out to be false in retrospect.
You're like listening to yourself, right? Regarding what the government says, you should just take your own action, right? So we shouldn't have any basis or listen to what the government is saying. Is that I'm just trying to understand. You got to make sense. I'm trying to understand what your argument is. Your argument is that even if the government is saying something, that you shouldn't listen to what the government is saying and you should take your own action because the government doesn't tell the truth?
Well, I'm not saying that the government doesn't tell the truth, Your Honor, but I think an important factor that needs to be considered here is whether the plaintiffs actually believed and relied upon the information that was being provided to them. If there's no allegation that they did so here, and in fact there are plenty of allegations that they disagreed with the decisions that were being imposed on them, and were vocal about that. They just simply chose not to file suit until when they did in January of 2016. And I see that I would like to reserve the remainder of my time for rebuttal if that would please the court.
I think Justice Cavanagh had.
The discussion requires that we first determine whether or not the fraudulent concealment statute actually applies, as the Court of Appeals said it did, but the Court of Claims said it didn't, to this notice provision, correct?
I believe that would, Your Honor, and I believe that it's clear by the controlling law that the fraudulent concealment statute doesn't apply to notice provisions, as we set forth in our brief.
But and I just have one question. So the notice provision in 6431 says that you file the notice or the claim. And here the plaintiffs filed their complaint, right? So why is that? Why are we not talking about, they didn't file a notice, they satisfied the statute by filing the claim. Why are we not looking at the limitations period where, because of the filing of the claim as opposed to the notice, and clearly, or at least I think even your side concedes that the fraudulent concealment statute was incorporated into, it did apply to limitation periods under the Court of Claims Act.
I would actually disagree that we agree that the fraudulent concealment statute applies to 600-6431, paragraph 3.
Because it doesn't apply to the notice period, or because it doesn't apply if it's construed as a limitations period?
Well, because a notice period is not a statute of limitations, and this court
But
is
this notice period allows you to file a notice or the claim.
either a notice or the claim itself. And in this case, they filed the claim itself, and they would have had to, that claim would have had to accrue, therefore, within 6 months of them filing the claim itself, which would have been July of 2015. Our point here in regards to the former emergency managers is that the claims against any of the former emergency managers in their official capacity had to accrue prior to that 6 month of the 6 months before they filed their claim itself.
Okay.
Thank you, Your Honors.
Thank you very much. Counsel.
Madam Chief Justice, Justices of the Supreme Court, may it please the Court, Paul Novak on behalf of the putative class. Also addressing the Court today will be Julie Hurwitz, who will be addressing the bodily integrity claim issues. I'll be addressing the other questions. I'd like to allocate 13 minutes of the time for me and 17 minutes for Ms. Hurwitz. Also sitting at council table are Michael Pitt, Teresa Bingman, Cynthia Lindsay, and Trishelle Young. I'd like to start by addressing a couple of, I think, factual misstatements that have been presented to the court in the presentation by the Assistant Attorney General. He indicated, well, the first one's not a factual misstatement, but I think it's incomplete. He indicated that the city had evaluated the use of the Flint River as the full-time exclusive source of water for the community and had concluded that it was capable of being used to safely provide water to Flint. I think that's somewhat incomplete, in that a more complete statement would have been that the city of Flint did evaluate the use of the Flint River and concluded that it would be far too expensive and take too long to prepare their own water treatment plant and to be able to pull that off. They made a determination it would be $50 million and take 5 years, 2 years simply to study the water before you flip the switch in order to safely make the transition to using the Flint water treatment plant and the Flint River on a full-time exclusive basis. And it wasn't the Flint City Council that made the decision to use the Flint River as was stated. That decision was made by Emergency Manager Kurtz, Treasurer Dillon, and with the governor's understanding that it would be the Flint River that would be used as an interim source. There was never a vote of the Flint City Council where the Flint City Council said, yeah, we will use the Flint River as our exclusive source for a 2-year period before the KWA was online. The only thing they ever voted on was the KWA itself. And I think that's an important distinction to be made. It was the state's choice through the emergency manager, the treasurer, and the governor to use the Flint River as the exclusive source, and to do so based on only a 10-month period of time to transition rather than the 5-year time that the Flint study determined was necessary in order to safely make the transition to the Flint River. The second point I wanted to make is with respect to, well, let me take a step back and talk generally about some of the facts that are at issue. Counsel for the AG made reference to the fact that we represent only 6 individuals. Actually, we represent a putative class, and we have an obligation to represent the interests of the putative class until such time that a class certification motion is presented and a determination with respect to that certification motion is made. So we represent all of the individuals within the city who have been damaged as a result of the actions that were taken by the state in exposing these folks to Flint water. And what has constantly happened throughout this process, we used a class definition that took the date of the switch to the Flint River and said, okay, for class definition purposes, that is the class of people who may have been impacted by these things. And the state has instead, and the city, have said, that's the date of injury. Well, nonsense. There was no lead exposure on day one of the switch to the Flint River. They make a great fact out of the fact that the color of the water changed relatively quickly, and the taste and the odor of the water changed. Lead is tasteless, colorless, and odorless. Somehow they're making this factual inference that because the water was discolored and smelled bad, that all of the citizens of Flint should have known that lead was an issue when it would provide no necessary factual inference
Counsel,
that lead was an issue.
never mind the color or the odor.
Sure.
In May of 2014, there had been numerous press stories about water quality problems in Flint. By June of 2014, many water users in Flint reported that the water was making them ill. In August of 2014, several boil water advisories were issued. January 20th, 2015, citizens' protests began and mounted. And on February 17th, there were public demonstrations demanding that Flint reconnect with the water system. Are none of those sufficient to give rise to a sense that there's a problem?
Let me go through a couple of those different instances, because the boiled water advisories, for example, issued from the city and from the state from time to time, and then were lifted with representations that the water is now safe to use again. There are clearly instances where the city was notified or the city provided notice to the citizenry that there were certain discrete issues that they should be concerned about, whether it was boiled water advisories, whether it was TTHM. We're not contesting that notification of those issues was not provided to the citizenry. What we are contesting are those instances where instead of appropriately providing those notifications, as they did in those instances, the state knew about particular problems and was silent. They knew about Legionella in the fall of 2014 and thereafter, and made no reference until, I think, a week after the governor's emergency declaration. He held another ad hoc press conference and notified people that, oh, by the way, there was a huge spike in Legionella deaths during 2014 and 2015. They made those observations with respect to TTHM, but with respect to lead, even though they were battling with the EPA internally as to whether, according to at least one EPA employee, the state's actions were bordering on criminal neglect, they made no reference to the public of any EPA or of any lead concerns throughout this time period. And in fact, to the contrary, Brad Werfel, the spokesperson for the Department of Environmental Quality, said that any parents who were worried about their children being exposed to lead should relax. So I think in many instances, the issues that they did notify the public about magnify even more for those specific and discrete harms like Legionella, like lead, and some of the other things, that they did not do so. And that's what we've been concerned about.
But isn't the question here not the propriety of the government's conduct at any particular time, whether it was silent or not silent or false or true in what it said? The issue here, very precisely under the statute, is when the claim first accrued. Is that not right?
The notice provision certainly.
And the notice
has-
provision imposes a much less burdensome obligation upon harmed persons than would the obligation of actually filing a lawsuit. This is just notice,
Well,
letting the state know that its coffers, its treasury, are in some jeopardy because there will be a claim made against the state.
The obligation to provide notice, I think, first of all, with respect to a number of these injuries, accrues, as Frank versus Linkner teaches, at that point in time when the damage or the harm, an actionable harm exists. For some children, there is a latency period between their exposure to lead and when there is actually manifestation of injury. For example, in the earlier Henry versus Dow decision, not the one that's been referenced, but the earlier one related to dioxin contamination, this court indicated it's not when you were exposed to dioxin that is the actionable harm, it's when you develop cancer. So I think in this instance, it's not when you have initial exposure to toxic water. And by the way, the toxic water fluctuates dramatically in terms of its corrosivity over this time period, in terms of the different chemicals that were in the water. The Maston article that we reference in one of our footnotes points out that its highest corrosivity wasn't until July of 2015. So there is not, on the incomplete factual record, because we've never had an opportunity to conduct discovery or obtain documents for purposes of this case, we've never been able to access the information about when not only the exposure would occur at the extreme corrosivity levels that would damage a house, but so the record with respect to those things is, I think, tremendously incomplete.
You seem to be saying pretty clearly that our decision 2 years ago in Henry versus Dow Chemical was wrong. And it may be. This is a very, like every other court in the country, it's a fallible court. It can make mistakes, and your understanding of what the law ought to be is not unreasonable, but perhaps it's not exactly what the law is, in fact, in this state right now. In Henry versus Dow, we said that the action there dealing with releases, polluting releases along the Tittabawassee River in the Saginaw area accrued when the dioxins reached the plaintiff's property, not when the plaintiffs first became aware of the damage to the property, much less when they first took sick because of the chemicals that had been released into the air there.
With respect to the damage that occurred here to the integrity of the infrastructure, which the governor recognizes in his emergency declaration, it is not the case that the water on April 26 of 2014 would have resulted in corrosion that caused the leaching of lead. That is a process that occurs over time, unlike the chemical constituents that are a case, dioxin, in Midland, where the day that dioxin hits your property is damaged as a result of it. In this instance, the corrosivity levels fluctuate and at times may not have even been an issue. And without a factual record, we don't know when it becomes an issue. And consequently, to say that corrosivity at any given time for any given property has resulted in an actionable harm, we have some class representatives who didn't have any demonstrable lead in their homes until after the water was switched back, because the corrosivity effects over time manifested themselves, not an immediate issue as there is with dioxin contamination. With that, I'd like to defer to my co-counsel I will say one thing before I'm leaving, though. The lawsuit that the defendants make reference to that was filed earlier by Ms. Mays, that was never presented to Judge Boonstra in the Court of Claims, and consequently, we never had an opportunity to supplement the record with a response to that. They brought it up for the first time in the Court of Appeals. We moved to strike it, and that motion was denied. If you would like us to supplement the record with the materials that we should have had an opportunity to present to Judge Boonstra with respect to that case, we'd be happy to do so.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Julie Hurwitz, and I'm here this morning with my co-counsel on behalf of the plaintiff class and the people of the city of Flint. This Court of Claims case has to do with holding the state of Michigan accountable for its role in violating the constitutional rights that these individual plaintiffs and class members had. Our complaint, which was filed nearly 5 years ago, presents an abundance of factual allegations that strongly supports the plaintiffs' Michigan constitutional bodily integrity claims against the state of Michigan. The Court of Claims and the Court of Appeals have both held that plaintiffs asserted a proper claim under the Michigan Constitution, and we believe that this court should do the same. This court asked us to address 3 questions on the issue of the Michigan constitutional claim in this case. Did the Court of Appeals err in recognizing a constitutional tort for the violation of bodily integrity under the Due Process Clause? Did the plaintiffs properly allege such a violation? And is there a damages remedy available for such a violation? My opponent this morning really has only addressed one small prong of that entire range of issues and questions that this court has expressed interest in. I will address that first, and that goes to whether or not we have alleged proper elements of liability under the Monell standard that the Smith Court declared to be the standard. And it's quite interesting to me, and I think ironic, that Mr. Gambill did mention York decision in Johnson versus Vanderkooy, and yet throughout their entire briefing in this appeal, they have articulated a standard that is diametrically different from that which this court has laid out as the proper elements of Monell liability under a constitutional claim. What this court said, and what we believe is the correct standard, is there are 2 questions when alleging a Monell claim. One, was a constitutional right violated, which we believe in this case clearly it was, and whether that violation was caused by a policy or custom of the governmental entity. And the question of establishing a custom or policy and what the role of the policy makers have been throughout the course of this travesty that occurred in Flint is Mr. Gambill and the state would have you adopt a standard that is so narrow and so diametrically opposed to what the prevailing law is that it would change the fundamental structure of the ability to hold a governmental entity accountable for its constitutional violations. The court found in Vanderkooy that in order to establish the requisite policy, that either the government itself engaged directly in unlawful action, which we believe occurred here through the explicit decisions that were made by numerous policymakers up and down or throughout the state government structure, from the governor's office down to the regulatory agencies MDEQ and MDHHS, through the official, those to whom power and authority was delegated to speak on behalf of the state. And also, however, the state can be held liable even if not directly engaged in an unconstitutional act, but rather if the government acted with deliberate indifference to the obvious risk that the failure to take a different course of action would cause the injury. Now, the state would have you adopt a standard that basically says that the state had to mandate the unconstitutional act to have occurred. And that's simply not the case. And that's not the standard that applies under the law. And as Vanderkooy stands for, the basis on which a policy can be established is there are a number of ways that a policy can be established. And one of those ways is if the state provides through its official policy makers a range of options or delegates authority for employees or officers of the state to behave in a number of different ways. And the employees or the officials choose one of those ways with which they have authority. And that way results in the violation of a person's constitutional rights. That becomes the policy that caused the constitutional violation. And in this case, we have alleged abundant factual allegations, to demonstrate and establish that there was tremendous knowledge that the official policymakers in the state of Michigan had from the time that the decision was first made to switch this water from the DWSD to the Flint River. They had been given all the information they needed to understand that this water was not safe, and that the water treatment plant in Flint was not equipped to properly process or treat this highly corrosive water. In fact, they were told, the state of Michigan was told by Mr. Glasgow from the city of Flint, who ran the water treatment plant, if you make this decision to switch this water, it is against my advice because we are not prepared to handle the highly corrosive water that was coming through, that was going to go through those pipes.
Counsel, didn't General Motors stop using the water because it was too corrosive for the vehicles?
Yes, they did, Your Honor. By October of 2014, this water was causing so much damage to the equipment in the General Motors plant that they made a special arrangement to go back to have an independent contract with DWSD because they were, and the state of Michigan, they got special permission from the state to switch back to DWSD, even though their plant was in the city of Flint.
Counsel, you've indeed made an argument that there were a lot of questionable, dubious, imprudent decisions made by government. I have no question that you're probably right in that regard. But please remind me which specific provision of the Constitution was violated here.
Well, Your Honor, it is the Due Process Clause, Article 1, Section 17 of the Constitution that was violated here, the right to bodily integrity. And the extent to which this state has adopted the same standards under the constitutional right to bodily integrity really should be no question anymore.
You know, I've been on this court for a number of years. I've never heard of the right of bodily integrity in Michigan law. That's not to say that I can't have overlooked some significant parts of our legal system, but I've never heard of that right.
I will agree that this court has never explicitly adopted the federal standard. However, this court has, and most recently in the Bowserman case, recognized that the Michigan Constitution is essentially coextensive with the federal Constitution, and that goes back to the case of Grimes versus Van Hook Williams, and also in Bowserman itself, and in Marville versus State Plumbing and Heating, Justice Markman, where you wrote that as to the Equal Protection Clause, at least, the Equal Protection Clauses of the Michigan and U.S. Constitutions are coextensive, even though if we're persuaded to that end. Correct, and we believe, Your Honor, especially in light of the Girton decision from the Sixth Circuit that has now been essentially adopted as the law of the case in the parallel federal cases that are simultaneously pending, the fundamental right to bodily integrity is deeply rooted and goes to the core of the notion of liberty in our civilized democratic society.
Let me ask you a question to try to explicate just a little bit of this right that, at least to me, is a new and novel right.
Certainly,
Let's
Your Honor.
say if miraculously and blessedly this week we discovered a vaccine for the coronavirus, and the state of Michigan decided to require all school children to submit themselves to such a vaccination. Would that run afoul of this new constitutional right? Can you tell me that with any certainty that it would?
I don't believe it would, Your Honor.
Why is
and
that?
that is the difference between the nature of the right that we are asserting in this case as opposed to, for example, the case that the defendants are repeatedly pointing to, which is Cascio versus Escondido. A decision made by the government that is rationally based in providing medical treatment that is legitimate and
reasonable. A rational basis
reasonable.
can't be a standard for defeating a constitutional right. I'm asking you this because if we do accept your invitation to create this new right within the Constitution, it's not going to be limited in its applicability to this case. It'll be applicable to 1,000 cases over the next decade. And we need to know what kinds of decisions are being removed from the representative processes of government and placed in the judicial process of government. It's important that we know that.
I understand that, Your Honor, and I think I would direct you to Cruzan versus the Missouri Department of Public Health, where the United States Supreme Court, under a similar situation where medical treatment was being offered to the plaintiffs and they chose to refuse that treatment, while the state has the right to provide medical treatment, it's been clearly established by the U.S. Supreme Court that everybody has the right to refuse that treatment, and it's the right to refuse the treatment that triggers the right to bodily integrity. And in Girton, under facts identical to those here, arising from this travesty in Flint, what the Sixth Circuit found was that these right to refuse medical treatment cases are very analogous to the situation that occurred in Flint, where you are provided, and the nature of the right that we're asserting here is not the right to clean water. It's the right for the government not to poison us. And it's the right for the government not to then lie about the poison. So the fact that they have, for example, in providing fluoride to a water system, the court has clearly established that is not a fundamental right to bodily integrity that is different from the situation here. So it's not a right to water, it's a right for the government not to lie to us.
You're right. What was suffered here was a terrible harm. There's no question about it. But it needs to be understood that not every harm affected by government implicates the Constitution. The Constitution protects things like the right to be free from unreasonable searches, and the right not to be subject to cruel and unusual punishment, and on and on and on. It is not an all-purpose remedy for every wrongdoing on the part of government, and I'm still trying to understand precisely what this new right that you would establish in our Constitution would do, what its breadth and what its scope is.
Well, Your Honor, I would direct the court, in answer to your question, to a series of U.S. Supreme Court decisions that define the parameter and scope of this right, from the Due Process Clause that has the exact same language as the Michigan Due Process Clause does.
Is it your position that if we do not recognize the existence of this constitutional claim under Michigan's Constitution, that Michigan's Constitution would be affording less protection to its citizens than the federal Constitution provides?
That is absolutely correct, Your Honor. That is exactly what would happen. We would have a situation where the U.S. Constitution, which has the same exact language arising from the same exact set of facts and circumstances as that which occurred here, and as recognized by the Sixth Circuit in Girton, that the Michigan Constitution would afford substantially less protection. And what I believe is very instructive, Your Honor, Justice Markman, in response to your question, is that when you define the scope of the right to bodily integrity, I would say it as the Sixth Circuit said it, that a government violates an individual's right to bodily integrity by knowingly and intentionally introducing life-threatening substances into individuals without their consent, especially when such substances have zero therapeutic benefit. And in this case, I would go one step further and say that not only introducing the poison into the pipes and the homes of the people of Flint, but then subsequently, when they knew it was dangerous, when they knew there was a public health emergency, when they knew that there was extremely toxic substances flowing in these pipes, they went out of their way within their respective official capacities, from the governor to the emergency managers to the spokespeople on behalf of MDEQ to the MDHHS. They covered it up. They lied. They told people it was safe. They took concerted steps officially by the state of Michigan to discredit the reports that were coming out from Dr. Monahan Atisha, that were discrediting the report that was coming out from Dr. Mark Edwards as to the severity of the toxins that this community was being exposed to. And this was all being done by the state of Michigan. And, Your Honor, if we cannot hold this state accountable for its role in perpetrating and continuing an ongoing invasion of poison into our communities, then I would suggest that our Constitution would not be worth the paper that it's written on. It is time. And this court, as far back as Smith, has held that the state may not immunize itself from violating its role in violating the Constitution of this state.
Madam
And
Chief,
my time is up, unless the court has any other questions.
Sounds like Justice Bernstein might.
no, I just have some questions for the state.
Oh, they're coming back, don't
Okay,
worry.
very good.
Yep. Thank you,
This,
counsel.
this court's decision will determine the fullness of the state's commitment to limiting the power of the government to invade fundamental freedoms of its citizenry enshrined in our state constitution. And I would ask that you affirm the Court of Appeals and the articulate and well-stated decision of Judge Boonstra from the Court of Claims. Thank you very much.
Thank you, counsel. You might just want to take Justice Bernstein's question off the top.
Counsel, good morning. I'm actually
morning.
going to take kind of a judge's privilege, and I'm going to see if we can set aside the clock, because I have a series of questions for you. And I'm going to ask you to give me a pretty extensive answer, and I'm also going to ask that you not be concerned about the time that it's going to take in which you're going to give me that answer. Do we understand each other?
Yes, Your Honor.
Okay. The question that I really would like to start with in terms of trying to understand your position, and I waited until the end because I wanted to hear all the arguments, but there was one argument that was not presented that I feel does need to be addressed. The lower courts made it quite clear that the residents of Flint and the people that are here today deserve their day in court. That's all we're here to determine. Whether or not they get their day in court and whether or not they have an opportunity to be heard. That's the only thing that is before us that we're trying to determine. What I'm trying to understand, and I'd like you to elaborate on this, and I'm not going to interrupt you because I want an extensive answer, is it is the position of the state that, which I don't doubt, that the conduct and behavior of officials was so egregious in the sense that people were exposed to poison in their water supply, which is going to affect the lives of parents and children, which is going to affect people in a very dramatic way for years to come. But the state made a decision, and make sure I'm pretty correct on this, that the behavior of state officials was to be so egregious that criminal prosecution was warranted, in which state officials, according to your office, should be subject to years in prison, very extensive years in prison. What I'm trying to understand, and I know my question is long, but I'm going to give you, and the court's going to give you, ample time to answer without interruption. If the behavior of state officials was to be so egregious that it warrants criminal prosecution, that it could result in years upon years within prison, why is it that you are here today ferociously arguing that the victims of this, the people who have to live with this, the people whose lives were changed for this, the same people that you are prosecuting for, should not be given their day in court and should not have the chance to be heard? Explain why. The lower courts have been pretty clear that they get their day in court. This was a decision that you made to come to our court. I'd like to understand why.
Your Honor, thank you for giving me the opportunity to answer that question, because I hope that it's clear, and we've tried to make it very clear in our briefs and today in my presentation, that the key issue here is that the plaintiffs are seeking to create a new remedy that does not exist. Right now, they do have multiple remedies available to have their day in court, Your Honor. But what they seek to do here is to create a new remedy. And they acknowledge on page 40 of their brief that the reason they're seeking this new remedy is just in case those other remedies do not work out. And so the legal position that the state of Michigan has taken is to adhere closely to what guidance this court has provided in the Smith case about when it would be appropriate for the judicial branch of government to unilaterally create a new damage claim remedy directly against state agencies. So the reason that we are here is to explain that the plaintiffs have not satisfied those burdens. In fact, the plaintiffs so misapprehend what the Monell burden is that they do not recognize that the Girton case that they rely so heavily on, decided by the Sixth Circuit, demonstrates that they do not satisfy the Monell burden. Even if, as the Girton case held, low-level state employees could possibly be pursued for substantive due process claims, Governor Snyder was dismissed out of that case. Nick Lyon, the director of DHHS, was dismissed out of Girton. Dan Wyant, the director of DEQ, was dismissed out of that case, all because the involvement of those top policy-making officials was too remote to support a claim. And that's the heart of the dispute here.
But doesn't that affect the, and I'm going to let you finish, but you're prosecuting these people. So if you're doing prosecution, you're saying that it's not tenuous enough for a civil case, but yet it is tenuous for a criminal case, which has a much higher standard and a much higher bar.
Now, I'll finish answering my question, but
Yes.
first I'll answer the question that you just asked, Your Honor, and I want to clarify, because often this is a misconception to the public, that I am not prosecuting anyone. There is a criminal prosecution side in the Attorney General's office that is completely separate. We do not know what's going on. And those prosecutions have actually been put on hold. Those charges that you referred to, Justice Bernstein, have been dropped for the time being. So just to clarify,
So are you not going to be prosecuting then?
that's not my decision to make, Your Honor. That's the point I'm trying to emphasize, that I'm not prosecuting anyone. side that we represent here is the civil side of the Attorney General's office. So to the Monell issue, the Guertin case shows that these top-level officials were too remotely involved. They weren't close enough to be liable for a potential substitute process claim. That
Counsel,
shows.
in the 1983 claim, the Guertin case, the state, and perhaps Snyder in his official capacity, was because of sovereign immunity, correct? That you can't sue the state under a 1983 action. But the Sixth Circuit has held that, in fact, these former emergency managers were, in fact, the plaintiffs have a viable claim against them. Some of them not, perhaps because of the attenuation. I think the MDHHS employees were too remote. But the MDEQ officials, the emergency managers, and the former public work director were viable defendants for a violation of the federal constitutional right to bodily integrity.
So, Your Honor, I have two responses to that. And first, to clarify, in response to your first question, the Governor Snyder, Nick Lyon, and Dan Wyatt were sued personally. They were pursuing claims against them personally, and they were dismissed because they were too remotely involved. It was too remote. A substantive process claim couldn't go against them. In response to your second question about the emergency managers, the Sixth Circuit, that's another way the Guertin case that the plaintiffs rely so heavily on actually weighs against them, because the Sixth Circuit expressly held that the city of Flint is responsible for the decisions of the emergency managers. And that's why we emphasize the McMillan case so heavily in our brief, because the U.S. Supreme Court has said, look, even if someone's a state official, that's not the question under Monell. The question under Monell is, whose government policy is this official making? And the Sixth Circuit held that it was the emergency managers were making the city of Flint's policy. The district court in the federal litigation also held, specifically in the Monell context, that the EMs were making city policy. And the Michigan Court of Appeals held that the EMs were held that the city of Flint did not somehow become part of the state just because it was under emergency management. So that's an important point that the plaintiffs have not dealt with in their brief in any meaningful way.
Is there a difference between saying that the EMs are not an arm of the state for purposes of 11th Amendment sovereign immunity and saying that their decisions can be attributable to the state for under the Monell as final policy makers of the state? Are those a different analysis, or are those in lockstep? They have to be in lockstep.
Well, to clarify, the analysis of whether the city of Flint or the emergency managers could assert 11th Amendment immunity in Guertin, one of the elements of that analysis is who's responsible for their decisions. So that's why it informs the Monell analysis, because one of the steps in that was who's responsible for the emergency managers' decisions, and the Sixth Circuit said the city of Flint is. And so that's why the city of Flint can assert 11th Amendment immunity. So that analysis, I mean, it demonstrates the point we're trying to make, which is that the plaintiffs have failed to demonstrate that the institutions themselves deliberately caused the specific constitutional violations they allege. And to be clear, this court has recognized the difference between a direct, deliberate action in the Monell context and an indirect, deliberate action in the Monell context. Unanimously, in the Johnson v. Vanderkoy decision, in the majority's response to the concurrence, everyone agreed that there's a difference. And the Brown case, which we discuss at length, walks the court through what the analysis is. It's one thing if there's a direct, obvious decision, like in the Monell case, the black and white policy saying, go discriminate against pregnant women. But when there's an inaction under Monell, there's two different ways to satisfy Monell. First, there's a pattern of past violations.
Counsel, I'm just going to ask one last question.
Yes.
You seem to say that there's this elaborate array of remedies that the people of Flint are able to have. Can you tell me what those are?
Yes. Every single one of these plaintiffs can file for damage claims based on the exact constitutional violations they allege here. They can file under 1983 against the state employees who they allege violated their constitutional rights. That's just one. They can also sue each of these employees for tort. That's another. They can also sue and are suing both Veolia and LAN, who are the engineering firms who Flint hired to advise them on how to fix the water. These plaintiffs were suing them too. In fact, the Attorney General is also suing them for professional malpractice. That's a third one. Another one is they can seek injunctive relief under the Safe Drinking Water Act, and the lead plaintiff in this case did just that in the Concerned Pastures case. They have multiple remedies available, including
But these are
damage
remedies that, these are not, I understand, but if you were to dig into these remedies, it's not going to really put these people into a position where their lives are going to be made whole. I mean, you're throwing out remedies, but if you were to look at these remedies, in the abstract, what you're saying is they could do these things, but practicality, if they're not able to hold the state accountable, it's not going to allow for them to even come close to being whole. I mean, is that a fair assessment?
No, Your Honor, but wait, there's more. I mean, they can also
There's more.
sue the United States Environmental Protection Agency directly, which they have done. That's how we know how much money that they're seeking. And so,
My last question, so basically at the end of the day, you're saying they can do all these things, but the one entity that's actually directly responsible for the harm that it's caused for these folks, you're ultimately saying that's the one entity that they are forbidden from. You can go and do all the other things, but it's your position that the real one entity that actually caused the actual harm in a direct capacity is the one entity that they're not allowed to. We're not even talking about whether they're going to be successful. We're just simply talking about whether or not they're going to have their day in court, correct?
no, that's not my position, Your Honor. The state is not the one entity responsible for the injuries they allege here. That is not the position we've taken at all. The position we've taken is that if this court is going to unilaterally create a brand-new remedy that does not exist, it needs to be very cautious about violating the separation of powers doctrine. And one of the key issues in that context is what remedies are available if it's necessary to create this new one, and they have lots that are already available. And thank you for your indulgence, Your Honor.
Thank you very much, counsel. The case will be submitted.